Marcia Greenberger. Marcia is the founder and co-president of National Women's Law Center, an organization that has worked to expand possibilities for women and girls. For over 30 years, Ms. Greenberger has been an advocate for women and has been a leader in developing strategies to secure the successful passage of legislation protecting women and counsel in landmark litigation, establishing new legal precedents for women. She has received numerous honors for her work, including being recognized as Working Woman Magazine by Working Woman Magazine as one of the 25 heroines who actively, over the last 25 years, has helped women in the workplace. She received a BA in law degrees from the University of Pennsylvania. Thank you for coming.
Thank you very much for the opportunity to testify here today and on behalf of the National Women's Law Center, and I am very happy to testify in support of the Paycheck Fairness Act. And I ask that my full written remarks be included in the record, and we'll just briefly summarize them then in the period of time that I have. And I do want to say at the outset that it is vitally important, as Dr. Murphy has said, that this piece of legislation is enacted into law, along with the Ledbetter Fair Pay Act, which is pending in Congress now, unless we have strong laws on the books that reflect a determination on the part of this country that women be paid fairly for their hard work and the skills that they bring and the contributions that they make in the workplace, then we're not living up to our ideals or the promises that we have made to women and the daughters of this country that we stand for equal pay for equal work. I'd like to talk for a moment or two about why the current Equal Pay Act has not lived up to its promise and why the law needs to be strengthened. Passed in 1963, it was seen as a landmark breakthrough to be sure that women who are working will get equal pay. But for several reasons, it has, over the years, not met the needs that the law was intended to address. First, courts, unfortunately, have interpreted the law in such stringent ways, certainly some courts, that it has been exceptionally difficult for a woman to demonstrate a violation even when she is clearly paid less on the basis of her sex. And with courts these days asking the legislature to be extremely explicit in the way that it writes our laws, it's up to Congress now to amplify on the Equal Pay Act to be sure that courts are not going to get it wrong in the future. In particular, we have seen with some courts an argument that even though under the Equal Pay Act regulations, when comparing the job that a woman has to a man's job, it doesn't have to be identical, and that minor differences shouldn't defeat a claim for equal pay. Some courts have allowed those minor differences to justify an employer's paying women less. As one commentator stated, there is now a point where, with some courts, virtually identical jobs are being required, but even more than that, and it has provided women with a very limited substantive right to equal pay as a result. In addition, under the Equal Pay Act, in contrast to Title VII's prohibition against pay discrimination, there's a defense of a factor other than sex which employers are allowed to bring to bear when defending against an Equal Pay Act claim. And the factor other than sex, by some courts again, has been allowed to be advanced when that factor has nothing to do with a business justification for the pay differential. And as a result, all kinds of inappropriate and unconvincing factors have been allowed to be advanced as a way of keeping an employer legally able to pay women less. Again, completely unacceptable. Further, the Equal Pay Act's procedures and remedies have not been sufficient as it's turned out in practice. In particular, and I know, Mr. Wilson, you mentioned the damages issue, Under our law in general, when there is an intentional violation, and that is what has to be shown in order to get damages, and for punitive damages, an even more stringent standard would have to be shown. Under the Equal Pay Act, that traditional remedy is not available. As a result, for all too many employers in this country, pay discrimination can be simply a cost of doing business. And if that employer isn't caught until many years go by without a compensatory damage and without a punitive damage remedy, it can actually be cost effective for employer to simply pay women less year after year after year, and the Equal Pay Act damages will not, that are available under the law now, will not fully compensate a woman for the damage that she suffers, and that's a damage that can go not only for herself and her family during her work life, but for pensions also during retirement, but it won't serve as a deterrent either. I know that my time is up, and as a result, I can't go through some of the other very important provisions in the bill that help with remedies, including the class action provision, which is important, the information provisions, which are important. And just to conclude, the Paycheck Fairness Act is a very balanced approach. It helps with legal enforcement. It helps with voluntary working together and facilitates that for employees and their employers. It helps for government enforcement, so it brings all of the private sector resources and public sector resources and the promise of this nation to bear to finally tackle the job of equal pay. Thank you.